Hi, can everybody hear me okay? I'm mic'd up here, and I'm stuffing wires in here to, I think I'm settled almost. Anyway, I want to thank Dr. Connor and the folks in the psychology department for having me today. Usually when you do a talk like this, you read all the books about public speaking, and they say you should open with a joke to loosen up the audience, right? So I do a lot of talks to lawyer groups, and if you ever go online, they have all those lawyer jokes. Like what's 100 lawyers at the bottom of the ocean? A good start. I used to open with those, but I found out lawyers don't like those jokes very much. So I don't open with jokes anymore. We'll jump right into it, okay? We're going to talk today about forensic psychology. Dr. Connor talked a little bit about my background, and I work at a practice called Human Resource Associates in downtown, and probably 80% of my practice is forensics. I was a prison psychologist for 7 years with the Iowa Department of Corrections, and then I went off to the Federal Bureau of Prisons, and that's where I received all my forensic training. And then I came back to Michigan, where I'm originally from, and started working for the Michigan Department of Corrections out in Ionia. At that time, they had 5 prisons out there, and I worked out there. And then after 7 years as a prison psychologist, it just wasn't interesting anymore. So I moved into private practice and started doing a few talks around town. And the federal courts found out that I was in town somehow. Well, scary, the feds find out things. It's weird. And they called me up and they said, hey, we trained you. Can you start to do some of our forensic evals? And I said, sure. And I got a practice up and going. I've been at Human Resource Associates for about 14 years now. What we're going to do today is we have an hour and a half. I'm going to do an overview of forensic psychology. I'm going to have slides. I'm going to talk about various aspects of forensic psychology. I'm going to show you some specific laws that as a forensic psychologist we have to look to and basically apply components of the statute in order to do the evaluation. I'm going to talk about the roles of a forensic psychologist, and I'm going to try to get through the slides fairly quick. And then what my goal is to get through the slides in the first half and get all that information dumped on your heads, right? And then for the second half of the lecture, open it up for questions. So what I'd ask is that if you have questions, kind of jot them down. And then when I get through all the slides, because a lot of times I found in these types of environments, and being in that seat as well, I tend to learn more from the questions. And sometimes one question comes out and it fosters other discussions and questions. So I'm going to try to run through the slides first, hold your questions, and then at the end we'll go through them. I hope I don't burst any bubbles. We're going to talk about the real world of forensic psychology, not the Hollywood version. I'm sorry to disappoint. You won't have a gun and you won't be running around in police cars after serial killers. You can do a little bit of that, but no guns. You don't get a gun, okay? Sometimes I show a clip of this movie, Kiss the Girls with Morgan Freeman, and he walks out with his badge. He says, I'm a forensic psychologist. I don't know if anybody saw that. It's an older movie. But no guns. Another thing I want to talk to you about is I'm going to tell you a little bit about what I do in my day-to-day job and sort of show you the kind of practical aspects of being a forensic psychologist. Now, warning. Every day, all day long, I talk to naughty people about horrible, awful things they do. So I have become really desensitized when I have these discussions. So I'm really trying hard to understand that I have an audience that doesn't talk with people who rape people and kill people every day. So I don't want to sound insensitive in some of the things we may talk about. Some of you may have personally dealt with. I don't want to make light of some of these awful things, but some of the things we might talk about, particularly if people have questions about cases, or some of the case examples that I might use might be kind of disturbing. Like I said, I'm working on not talking about it so casually. If after the talk you have any type of reactions, or if you get emotional, please come and see me, okay? Not at my practice. Come see me after, okay? And we can talk a little bit if you're having a hard time. It hasn't happened yet, but there's a possibility. So I just want to warn everyone, some of the topics we may talk about may be kind of disturbing, all right? All right. A good place to start when you're going to have a discussion about an area in any science particularly psychology, is to start with a basic definition. So the basic definition is for forensic psychology is the application of psychological science within the legal system. Now, there are other examples of forensic. Don't you love these pointers? They're so cool. We used to have a big wooden stick we used to point with, but not anymore. Love technology. Other examples of forensic. So forensic pathology. That would be, for example, I'm doing an autopsy and trying to find out the cause of death. Because when you find out the cause of death, that could end up in a legal situation, right? Forensic science. That's the stuff like CSI stuff. Blood splatter analysis, hair analysis, DNA analysis. Right, so anytime we're using, it's kind of general science in the forensic setting, or science in court, then it becomes forensic. Forensic dentistry. What? I met a forensic dentist once. Guess what they do? They identify remains. So if there's remains of a body found, right, they'll get the dental records. They also do some work in bite mark analysis, right? Forensic accounting. The FBI does a lot of that kind of stuff, right? If you're cooking the books in your business and you're not following standard accounting principles, a forensic accountant can come in and they can use evidence that they gather through analyzing your records to use it in a legal situation. History of forensic psychology is kind of interesting. So historically, psychologists have had kind of a weird relationships with the court, okay? Originally, 100 years ago or so, mostly social workers would be involved with the courts, and particularly with juveniles. But as time went on, psychologists became more and more involved, and probably not until the 1960s and 1970s did we really see a lot of psychologists becoming involved in forensic work. There's been, and you probably from your own research or consuming of media, there's been some sort of egregious kind of work that psychologists have done in legal situations, right? That stereotype of the person getting off scot-free with, murdering someone. But the history of forensic psychology goes all the way back to a dude named Hugo Munsterberg. Don't you love that name? If I have another kid, I want to name the kid Hugo. This is his book, On the Witness Stand, 1908. And some of the things, 1908, and if you took PY 201, I know that you've been talking about the history of psychology, and 1908 was right at the beginning of psychology as a science. So Hugo wrote chapters on the memory of a witness, the detection of crime, hypnosis in crime, the prevention of crime, untrue confessions. These are actually contemporary issues that we deal with in forensic psychology all the time. There's a thing about false confessions. Maybe you've seen that in media stories. I've had to do evaluations for people that have, that there's been some argument that they made a false confession. Hugo talked about it in 1908. He's known as the father of forensic psychology. Whoa. The broad area of forensic psychology. We're going to cover some of these in depth, but I really wanted to kind of give you an overall look, I guess, at all the different areas that fall under this umbrella of forensic psychology. So remember, if you stick with the original definition, which is anytime psychology is applied within the legal system, all of these apply. So some of the stuff we're going to talk more in depth. Insanity, you've all heard of that, right? Competency to stand trial. Guardianship, right? Do you need a guardian because you can't manage your own affairs? Well, that becomes a legal situation, right? I do a fair amount of guardianship evaluations. Child custody evaluations. If mom and dad are getting divorced and they're fighting in court over custody of the children, that becomes a legal issue, right? So I will do child custody evaluations too. Police psychology, really? Yes. So understanding the demands of police work, understanding some of the ramifications of police work. So if you were a police psychologist, you're probably going to deal with some post-traumatic stress disorder, right? Not uncommon for police officers sometimes to experience that based on their work. Fitness for duty, So I had to do a fitness for duty, actually evaluation for another psychologist who got in trouble. That was just recently. Jury selection, risk for sex offending. Sometimes I have to evaluate people for the court and provide a risk based on the science of sex offending, what their risk will be. Disability, I do a fair amount of disability work, because if you're on Social Security disability, it actually becomes a legal issue, right? There's a legal a legal aspect to disability. There's laws about disability. Americans with Disability Acts, a lot of times that one will fit over here to my friend's civil litigation. People get fired from their jobs, and they said, you fired me because of my disability. So the Americans with Disability Acts is a very specific law, and sometimes I'll work on some of those cases too. Fitness to carry a firearm. That's an interesting area. So, you know, in Michigan, being a state where concealed weapons permits are not that difficult to get as compared to other places, or even as compared to 10 years ago, occasionally someone will get rejected by the governing body that issues those permits. And they'll try to find a forensic psychologist to do the evaluation of whether or not they would be fit to carry a firearm. We, in my practice, have decided to not do those because the law about what needs to be involved in the psychological evaluation, for me to say it's okay for that person to have a firearm, even though they've got 3 domestic violence arrests and they've been hospitalized for psychiatric reasons on 5 occasions, high risk, and it's a kooky law. So that's the one thing in my practice that those of us who do forensic work will not do anymore. So it's a broad, huge area, and we're going to expand into some of these more in depth. All right. Roles of a forensic psychologist. This is very important, and this is an interesting piece to understand. So the basic roles of a forensic psychologist, number one, examiner. So if I'm an examiner as a forensic psychologist, I'm doing a psychological evaluation on someone. I might do an evaluation to assess their competency to stand trial. I might do an evaluation to assess their psychological capacity to parent or fitness to parent. So for example, we'll do a fair amount of work in capacity to parent. If someone's child gets removed from their custody and put into foster care because of neglect or abuse, then that person will likely have to go see a forensic psychologist, someone like me, to do their evaluation. And why is this a legal issue? Because when Child Protective Services takes over control of your children, that is a legal situation. They gain what's called a wardship over the child. And then if after a year you don't get your act together, they try to terminate your parental rights, and that becomes a legal issue too. So examiner is when you actually do the evaluation and examine a person. Consultant. Consultant can be a very broad range as a forensic psychologist. So sometimes I'll be hired as a consultant by an attorney to do a records review. So I might go through the records, and what's really fun sometimes is I have to critique other psychologists' work, which is a cool thing to get paid to do, right? You may be a consultant in a trial. I've been hired to sit in a trial and do the, scratch the notes on the notepad and hand it to the defense attorney. I've done a fair amount of work in as a consultant with helping attorneys develop cross-examinations of experts on the other side. So the other side brings in an expert, and then I'll have to help them develop the cross-examination questions or develop the line of questioning. Treater. So providing treatment as a forensic psychologist most often has to do with treating someone who's been found not competent to stand trial. And we'll talk more about that in a minute, but if you're found not competent to stand trial, under the law, there needs to be some type of intervention that can be employed to try to get you competent. Also, some work I do in family law has to do with, it's called parenting coordination. 2 parents that are divorced, or even if they weren't married, but they share custody of a child, and they have a hard time making decisions about that child, and they have to go to court all the time. The judge sometimes orders them to me. And it's not mediation, but it sort of looks like mediation. And I sit in the room with the 2 parents, and it's a treatment intervention where I try to get them to communicate with each other and to make decisions about their child that's in the best interest of their child rather than go to court. As a consultant, a lot of times I'll get hired and I'll go through a case, and I find out that the clinicians involved in the case have been the examiner and the treater. And then that becomes an ethical problem, because in forensic psychologist ethics, they say you need to pick one of these. If you pick more than one, it's called a dual role. And there's ethics in general the general ethics for psychology talks about trying to avoid dual roles. But in forensics, it's especially important. So a lot of times if I see someone who is the examiner, and I could give you all kinds of awful examples of people who became the examiner and then started doing family counseling with the family, and it just muddied the waters in the court, caused all kinds of problems. They had to basically throw out all the opinions and start from scratch, costing everyone thousands of dollars and hundreds of hours. So it's important for forensic psychologists to define what they are and to stay within those roles. All right. Applications of forensic psychology. So a person who's a forensic psychologist a lot of times has a lot of training in law and in psychology. So for example, I was fortunate enough to go through the training program at the Federal Bureau of Prisons for a year. I was in Lexington, Kentucky. And we had to read all kinds of case law and have all kinds of legal training. And we had our psychology training already. And then we had to go into court. We had to work with, we had a retired federal judge who used to come in, and we would practice cross-examination with him. So we had to go through a whole legal training program. There are some folks who do forensic work that have gained the legal training after they became sort of the general regular psychologist. So that's something you can do as well. So the idea is that as a forensic psychologist, if you're competent, you've been trained in both law and psychology. So some of the things that a forensic psychologist would do: become involved in criminal proceedings, do a pretrial evaluation. And we're going to expand on these in a minute, but if I have to evaluate someone before the trial and give an opinion about their competency to stand trial, that's going to be a pretrial. In trial, that can be consultation, sentencing. As a forensic examiner, I might do an evaluation for the federal courts about departure of sentencing. So sometimes the forensic psychologist will get involved in a case at the sentencing phase. So for example, a sex offender risk assessment. In Canada, if you want, if you get convicted of a sex offense, before you are sentenced, you have a comprehensive forensic risk assessment by a forensic psychologist. The Canadians are miles ahead of this kind of stuff as compared to the States. So why do they do that? Well, the Canadian Solicitor General said, we're going to do this because we want to make best use of Canadian taxpayer dollars. So let me give you a real-world example. Flashers. You know who these guys are? Who expose themselves, right? It used to be the big raincoat, right? Flashers are actually pretty easy to treat psychologically. But, so for example, in Michigan, you might see a flasher who gets prosecuted under the Sexually Delinquent Act, which is a law, and they've been convicted of flashing before and didn't get any treatment. After the third time, they could do life in prison. Now, is that a good way at, what's it cost now, $60,000 a year to keep someone in prison? 37? Is it? Okay. That's a lot of money, isn't it? Yeah. And there's like 50,000 inmates. But anyway, so in Canada, what they would do, typically, or stereotypically, is they'd get the flasher in, and for sentencing, they'd say, you know what? It's better use of Canadian taxpayers' dollars to put this person in the community, have intensive probation, and have them see a psychologist to treat their problem. Where the other side could be, if someone is a pedophile who has an appetite towards children that are under 5 years old, we know based on the research that that person is probably going to be high likely to offend. So, for example, in the Canadian system, they would probably say he's a high risk to reoffend, and they would imprison him much longer. All right? So, in Canada, in my opinion, they do the right thing, and what they do is they focus on the science behind their decision. In the U.S., we focus a lot on the politics behind the decisions a lot of times, right? Okay. Family court. I already talked about that. Family court would be divorces, mostly. So people are fighting over custody. Mom says dad's crazy. Dad says mom's crazy. Judge says, Jeff, figure it out. Most of the time the people aren't crazy, but they're going through a bad time and they're maybe not acting the right way. So a lot of times they'll do these evaluations and I'll say, mom's okay, she doesn't have any mental illness, she's a good parent. Dad's okay, he doesn't have any mental illness, he's a good parent. They're not dealing with the situation well. And then the judge will say, you two sort of need to knock it off and quit bringing up these questions. You both have the necessary psychological capacity to parent. And probate court would be things like guardianship. So if you have a mental illness or if you have dementia and someone wants to get guardianship over you, you would go to probate court. And civil litigation, which I accidentally skipped, has a lot to do with suing. So if you want to sue someone for emotional damages, you might go see a forensic psychologist to get your evaluation. All right, we're just flying through these, right? Okay. Yeah. We're going to go through all that. And the one thing, what I'd like everyone to do is when questions come along, because I'm going to try to blow through the slides as quick as I can, and then have the questions at the end, because that's what happens a lot of times. People have a question, and I'm already going to cover it here in a minute. Okay? So often your task as a forensic psychologist is applying psychological science to the legal statute or principle. So a good forensic psychologist knows the science, the psychological science behind sex offender risk variables and sex offender risk assessment. And the good and well-trained forensic psychologist does an evaluation of the person and does the evaluation within the context of what the science says about what the risk for that person would be. And then the good, well-trained forensic psychologist goes into court and testifies and educates the court about this person's risk. And then the court, the model would go, can make an informed decision about what to do in sentencing, for example. All right? So that's why it's important to have good training in the law, because what you're going to find here in a minute is, as a forensic psychologist, I have to read the law and find out what the law says about this particular issue that I have to weigh an opinion on. Here's an example of the Michigan law for criminal responsibility. MCL is Michigan Compiled Law, section 761.21a1. So, this is what the law says. If, as a result of mental illness or mental retardation, as defined in this law, that a person lacks substantial capacity to appreciate the nature and quality or the wrongfulness of his or her conduct, to conform his conduct to the requirements of the law. Criminal responsibility is also known as insanity. In Michigan, we call it criminal responsibility. In the federal law, they call it insanity. And different states vary. But if you look at the definition here, a criminal defense asserting that at the time of the commission of the acts constituting the offense, the defendant, as a result of severe mental disease or defect, was unable to appreciate the nature and quality or the wrongfulness of his acts, and that a mental disease or defect does not otherwise constitute a defense. So, believe it or not, these definitions, legalese, right, are pretty similar. So an example of criminal responsibility or insanity would be, I had a case when I was with the feds with a guy who was a bank robber. And what he did was, he walked into the bank and said, "You SOBs, you took all my money. I want my money back now. Give me my money, or I'm going to blow this place up." And what did they do? They handed him a bag of money. He went across the street to McDonald's, walked in, put his bag of money on the counter, ordered his Egg McMuffin, went back to the picnic table outside McDonald's, sat there with his bag of money on the table, and started to eat his Egg McMuffin when the police showed up. And the police showed up, and they said, "Hey, what's going on?" I'm sure they said something else, right? And he said, "Those SOBs took my money, and I got it back." This person had schizophrenia. They had a delusion that the bank had somehow stolen all of his money. That was a case of not guilty by reason of insanity, right? Did he understand, or first of all, did he have a mental illness? Yes, he had schizophrenia, right? That's defined in here. And in the law, a lot of times they call it mental disease or defect. And then what you have to do is, what does mental disease or defect mean? You look back at what's called the case law, or cases that have been solved along the way, and that's really defined what those things really mean. And that did this person lack substantial capacity to appreciate the nature and quality of the wrongfulness? Yeah. Now, what if he would have went in and said, "You SOBs, give me my money"? And they would have gave him the money, and he would have jumped in his car, and he would have took off, and he would have hid the money. And when the cops showed up, he'd say, "I don't know what you're talking about." Did that person understand the quality or wrongfulness of his conduct? Yep. So when I do these types of evaluations, even if the person's mentally ill, if they tried to cover it up, they kind of knew it was wrong, right? Okay. The other part is to conduct or conform conduct to the requirements of the law. I do a fair amount of work in juvenile courts too. And I had a case years ago where a 14-year-old kid with severe ADHD and an IQ of about 75. If you know what IQ of 75, we're talking about, what, third percentile? Not quite mentally retarded, but close. He's off his ADHD medications and very hyper. Mom takes him to Meijer. He's standing in line at Meijer. There's a woman in front of him with her 2 kids. He reaches out and gives her a big squeeze on the butt. She flips out. Security comes over. They arrest the kid and charge him with criminal sexual conduct. Now, we found out that when he's on his ADHD meds, he wouldn't do that. He had some control. So the argument was that he was not criminally responsible because of his mental disease or defect, ADHD, and then he laughed after he did it. He didn't try to hide it. Because of his ADHD, and maybe a little bit contributing from what was diagnosed as borderline intellectual functioning, caused him not to be able to conform to the conduct or the requirements of the law. Does that make sense? But a lot of times you'll see these insanity pleas have really gotten a bad rap. So for example, this only works in less than 1% of the time that it's brought up. There's been famous cases. Remember a guy named Jeffrey Dahmer? I know I'm going back a few years. Remember that case? He said he was insane. He wasn't. Sirhan, who shot Bobby Kennedy. I know I'm going way back for you guys. But if you studied history, you'll learn about that, right? He said he was insane. He wasn't. John Wayne Gacy was one of the most notorious serial killers in the 70s, killed 33 young men and teenage boys and buried them. Told you it'd be disturbing, right? Buried them under his house. He said he was insane. The court said he wasn't. All right. So this does not work very often. It gets a bad rap. People think it's a get-out-of-jail-free card, but it's actually not at all. Okay? So people getting off by reason of insanity is very rare. Now, there are a few big cases in the 70s where this worked. But what happened is before the 1980s, the way these laws were written, they had a thing called the burden of proof. And the burden of proof before the 1980s was on the prosecution. So the prosecution had to prove the person was sane. That's a tough job sometimes. In the 1980s, because of some high-profile cases, most of the laws in the states changed over. And now the burden of proof is on the defense. So if you're claiming that you were insane or not criminally responsible, the defense has to prove that you were insane or not criminally responsible. That's a lot higher hurdle than not having to prove that at all, right? So this isn't a get-out-of-jail-free card. It hardly ever works, okay? When it does work, you're going to hear it all over the news. But most of the time what will happen is we'll have cases where we'll do the forensic eval. The prosecutor looks at the results and says, okay, well, if you promise to get your person into long-term psychiatric care, we'll suspend sentence or something. Okay. All right. Cruising along. Competency to stand trial. This is a different law. It's a pretty common forensic issue. MCL 330, right? This is the Michigan law. A defendant to criminal charges shall be presumed competent to stand trial. He shall be determined incompetent to stand trial only if he is incapable because of a mental condition, mental disease or defect, the law likes to say, of understanding the nature and object of the proceedings against him, or of assisting in the defense in a rational manner. The ability to perform the tasks reasonably necessary for him to perform in the preparation of his defense and during trial. Basically, the question that I have to answer. So that's what happens when you're a forensic psychologist. You look at the law, you pull out a couple of questions, and then you have to do the evaluation, gather the data. It's a very sort of empirical process. You gather the data to answer the question. So the question that I have to answer, in competency is, number one, does this person have a mental disease or defect? And in the case law, it's either mental illness. Not every mental illness not just because you have mental illness means you're not competent. Okay? But my first question, do they have a mental disease or defect? Do they have a mental illness? Or do they have mental retardation? The second question, because of that condition, did the person not have an understanding of the nature and object of the proceedings against him? So if you came into court and you had an IQ of 51, you're moderately mentally retarded, right? You definitely probably would read at the kindergarten level. Would you be able to understand what was going on in a criminal proceeding? And the other part is, because of a mental disease or defect, is this person not able to assist in their defense in a rational manner? Okay. Now, competency to stand trial doesn't work very often either. In fact, it's only successful about 15% of the time. So let's say we do your competency evaluation, and the examiner says, this person's not competent to stand trial. Then what happens is the court says, okay, can this person be restored to competency? And then I have to provide an opinion based on the science behind the mental illness. Can we do treatment or education with this person and make them competent? And different laws say different things. In Michigan, I think it's 15 months. So I have to provide an opinion to the court whether or not we can restore this person to competency in 15 months. Let's say we can. Then they go into a restoration program through the Department of Corrections here in Michigan, typically. And then they get treatment. So, for example, if someone has schizophrenia and they're not able to sit in the chair because they're flipping out because of their symptoms, and we get them on medications, and we give them some counseling to understand their illness, and we get them competent to stand trial, now we can have the trial. There are some situations where the person's not competent. Just last week, I saw a 13-year-old who was accused of assault, took a box cutter after his mom. Yeah. He had an IQ of like 51. He had an endocrine disorder. What? He had an endocrine disorder that affected his thinking ability, so he had a medical problem that affected his thinking ability. I made the opinion after you do specific competency testing. You talk to the person about what does a judge do, and they tell you. And you also, there's all kinds of specific competency testing. If you were in court and A, B, and C happened, what would you do? A, B, C, or D? And you see what their knowledge level is. Well, this kid didn't really have the brain power to be able to even learn that stuff. And because of the endocrine disorder, he was impaired to the point where he just was not going to be able to conform his behavior to what they, to be able to sit in court and contribute to the defense. So I made the opinion he wasn't competent to stand trial, and there was not a reasonable likelihood that he could be restored to competency within the statutory amount of time. The prosecutor accepted it, and then they dropped the charges. So if you're not competent to stand trial, you can't go through with the trial. Now, you also have to be competent to be executed. So anybody want to guess what two states have very well-funded, wonderful competency restoration programs? Texas and California, he says. Texas and Florida. If you're found not competent to stand trial in Texas, you go live in a nice prison, go to class every day, and they do a really comprehensive, good competency evaluation or competency restoration. Because you can't, I think, I might misspeak, but I know those states tend to have a tradition of having maybe more capital cases than other. Maybe there's another state that's kind of moved in, but those two kind of have the stereotype of that. Okay, now. Juvenile competency to stand trial. In Michigan, up until 2013, we had to apply the adult statute of competency to kids. And at this time, about 50% of the states, and by the way, most of the states define competency the same way. The wording might be a little different, but it's pretty much the same. There's a whole history of things called the Dusky Standards and all kinds of other things we could get into, but it's kind of beyond our discussion today, that really serve to develop the idea of what competency is as a construct. In Michigan, up until 2013, I would see juveniles who would come in, and their cases were a lot more complicated. So if you're 15, your brain's not mature yet, and you have a learning disability, and you've got some problems at home, and you got some ADHD, maybe you got fetal alcohol syndrome, are you competent to stand trial? Those cases, and there's a whole aspect of emotional maturity. So those cases would be very complicated, and we didn't really have a good statute to base things on. In 2013, the Michigan legislature, and I'm a big critic of state legislatures, I've got some stories. They usually make bizarre laws that aren't even applicable. Not usually, but sometimes. They came up with a great law that outlined all the things that we need to do. We need to give everybody an IQ test who's a juvenile, and we do competency eval. You have to be a qualified forensic examiner. So I had to go to a specific training in Ann Arbor about how to do these, even though I'd been doing them for 10 years. And our restoration, if we found them not competent, was 120 days, 4 months. Because I'd have these problems where I'd get these 15-year-olds with learning disabilities that would do something wrong. And I looked at the adult statute, and I'd say, okay, so how much is this kid going to mature from 15 to 16 and a half? And it became even more complicated. Here they say if you can't restore competency in 4 months, 4 months? Yeah, 3 months. No, 4 months. 4 months, right? Then you have to drop the charges. They also outline other specific tests of competency relevant just to juveniles. Did they have an ability to extend thinking into the future? Well, if you take adolescent development or child psychology, child development, or even in your PY 201, your general psychology, you're going to learn that there's a whole thing called hypothetical thinking, and on a good day, that's wired in by 12, but not everybody's having a good day, right? So some kids, they don't get that until later, and some might not even get it at all. So one of the hallmarks of adolescence is not being able to see in the future, right? Okay. So we have to actually look at that and try to measure that. And then verbal articulation abilities, or the ability to express oneself. So it's going to be important to assist in your defense. You're going to have to be able to communicate with your attorney. So now under the juvenile competency statute, we have to look at those specific things and provide an opinion and attach that opinion to our overall opinion on whether or not the person's competent or not. All right. I see a few people getting bored. So whenever you do talk like this and when I teach, if people get bored, you have to try to attach sex to So I'll try to think of some some sex cases to get you guys interested. Or you just drop the F-bomb when you're lecturing, and then it gets everybody awake, right? I'm not going to do that. Okay, guardianship. I'll tell you a good story about guardianship. So guardianship, do you need a guardian? Are you an incapacitated person, unable to conduct your day-to-day affairs? And they need to be incapacitated due to mental impairment, retardation, old age, or disease. I've had a few cases where mom is a widower. Mom has millions of dollars. Mom's in her 60s. Mom has a couple of crappy kids who are adults now. Who want mom's money? Kids. And one case I'm thinking in particular, they filed a petition in probate court. Mom owned a big mansion on Lake Makatawa. And one kid was nice, two kids were not nice. They filed a petition to gain guardianship over mom and to be her conservator. Basically get access to all her money. This woman was 72 years old. She drove herself to East Grand Rapids every Tuesday to play bridge with her friends. We did her cognitive testing. They said she had dementia. We did her cognitive testing. She did amazing. Particularly, at 72, you might see some age-related declines. She didn't even have those. She was a brilliant woman. Very sharp, very together. So I had to do her evaluation for guardianship. I said, this woman is smarter than, half the people I know. And she's really together. There's no mental disease or defect operating. So they threw out the case. Okay? All right. These can get kind of complicated sometimes, particularly if families come in. And you might have someone who's got a drug problem. How does having a drug problem fitting into being an incapacitated person? Is a drug problem mental impairment, retardation, old age, or disease? It's tricky. Little side note. We'll go back a few. I want to show you something. Insanity. If you get drunk and kill someone, you cannot plead insanity. Voluntary intoxication takes insanity off the table. So you can't use that as an argument anymore. I had a couple of cases where it was involuntary intoxication. One, hope you don't know this person, it's in the public record, so I'm not violating confidentiality, ended up in an emergency room in a rural community, I won't tell you where, and he had drank a bunch of antifreeze as an attempt to kill himself. So in this rural hospital, they decided they needed to intervene so he would not die or cause organ damage. So they prescribed him bourbon, whiskey. Yeah. They prescribed him, something like 2 shots an hour. After he drank a fifth of Old Crow or something in the hospital in about 6 hours, he wanted to go out for a smoke, right? The nurse said, you're not going anywhere. He got in a physical altercation with the nurse and cut the nurse with a scalpel. Why were there scalpels laying around? I don't know, but it was bad. That became a case where they were claiming a lack of criminal responsibility. So I had to sit and figure out, based on the guy's body weight, his history of alcohol use, if he drank a fifth of 100, it was 100 proof whiskey too, it wasn't, If he drank a fifth of 100 proof whiskey, was he able to appreciate the nature and wrongfulness of his acts? Was he able to conform his behavior to meet the law? I actually said he wasn't, because he was wasted, but not voluntary. He was wasted under a doctor's orders. And you're going, prescribing whiskey? A guy I know who's an ER doc, I called him up. I said, Brad, listen to this. And I tell him. And he goes, you know what? He said, that is actually an old-time treatment for a glycoalcohol overdose. He said, when I do it in the ER, we do a drip, and we don't give them that much. I had another case of this is all in the public record, of a federal agent in Grand Rapids years ago who was stealing people's identities and going to ATMs and plugging the ATM card in the camera right there and getting $20 out cash. She was on so many pain meds, she would fall asleep in the parking lot with a cigarette and there'd be a hole burned in her door. So the physician who was prescribing the medications was, and I got a physician involved too, and he looked at it and he said, I'm surprised this woman's alive. She was just so out of it on pain meds. But what's interesting was, stealing the identities of the people didn't meet the criteria for insanity, but using the fraudulent device did. Isn't that interesting? So we had a couple of behaviors. Stealing the identities, she was okay. You know, she was sane for that. But then when she actually went up to the ATM and put in and got 20 bucks back, but they ended up cutting a big deal with that one anyway. But that was kind of an interesting, different type of case. So anyway, voluntary intoxication takes it right off the table. All right, I'll blow through these. When I do a guardianship eval, I need to get very specific about all the things. I need to list all their medications, their dose, and any effects each medication has on a person's behavior. And you got to do a prognosis for improvement, because if they want, they'll get rid of the guardian if there's a good chance for improvement. Risk assessment. I already mentioned this. Sex offender risk assessment sometimes is something you get called on to do as a forensic psychologist. Like I said, in Canada, they do these, particularly for sentencing. What you do is you take the body of research literature on who's more likely to sexually offend based on all kinds of variables, based on what kind of offense they do, based on other aspects. Do they have a mental illness? Do they have a substance abuse problem? Have they failed in their probation before? These are based on what's called actuarial data sets. And before, although insurance companies say they don't do this anymore, before insurance companies used to use actuarial data sets. And if you bought a red car, your insurance costs more than if you bought a blue car back in the old days. Because they would show statistically through actuarials that if you had a red car, you were more likely to have an accident. So when I do a sex offender risk assessment, I look at what actuarial variables are associated in the research literature with your risk to sexually offend. There's also an area called dynamic or changing variables. There's a whole body of literature on that. So when I do the sex offender risk assessment, I get the person's life story, I do some psychological testing, and I look at what variables are tripped. And then you come up with an estimate of, you know, are they high risk, low risk, moderate risk, those types of things. You also apply an actuarial model to risk for violence assessment, domestic, workplace, institutional, or school. I've evaluated people who made bomb threats at GRCC on their risk to do it again in their sentencing. I've done workplace violence. Someone gets mad at work and says, I'm coming back to shoot up the place. So I got really busy doing these after there would be sort of national tragedies, right? Remember Columbine, things like that? Anytime there's an institutional shooting like at a college or university, I'll end up getting a few of these. Some kid up at Rockford decided to throw a rock through the principal's window after school one day. I'm going to kill you. He came to my office. I had to assess his risk. So again, you apply the science. And in this case, where it gets interesting is, there is no law about sex offender risk assessment. Competency, there's a law. Gives me a great question to answer. So what you have to do as a forensic psychologist is you have to look at the literature, the research literature, and really depend on that to answer your questions. So this brings up an important point. Sometimes as a forensic psychologist, you have a very specific statute that you follow and answer all the questions. Other times you don't, and you have to go to the professional and research literature to answer your questions. Family law. There is no law that says what a fitness or capacity to parent is. But there are bodies of literature, research literature that tells you what that is. You have to know those and apply those to the examination of the person so that can be kind of extrapolated to the court's decision and laws. Michigan has the Child Custody Act. These are factors the court has to consider in order to award parenting time and custody, mostly custody. Sometimes I will be charged with doing a forensic psychological evaluation that's called a custody evaluation. And in a custody evaluation, I evaluate mom, I evaluate dad, and I evaluate all the kids. And in a custody evaluation, I have to weigh in on these factors. Most of these factors, I'll say, the evaluation was not specific to address that factor. But can I address A, the love, affection, and other emotional ties existing between parties involved and the child? I can weigh in on that. And I might weigh in and say, Mom has a closer relationship than Dad does. But they have to consider all these factors. E, this is a weird one, the moral fitness of the parents involved. As a scientific-based psychologist, when you say moral to me, I get a little nervous, okay? But what you have to do is when you think about morals, and you think about how does this person's sort of moral fiber impact the child. So for example, I see lots of people, well, did I say lots? Yeah. People are swingers, sexually open lifestyles. People who, I saw a couple people who have adult-oriented businesses, sexual-oriented businesses. Does this make you a bad parent? Well, you say, no, it depends. You've got to be in your bedroom. Whatever's in the bedroom stays, that's your business. But one example I had was, this gets gross, sorry. I had divorced, this was a divorced family, and there was a custody fight. And mom and new stepdad, I hope you don't know these people, would take the children, age 6, 7, and 9, to conventions. The convention they took the children to was Seasons Beatings. It was kind of a cute little flyer. Let's go on Christmas time. Instead of Seasons Greetings, it was Seasons Beatings. It was a bondage conference. Do you take your 9-year-old to a bondage conference? Would I say it's immoral? I wouldn't say that, but I'd say it's probably not typical to sort of the moral standards of our culture, right? Where this gets really funky is nudists, right? I've had nudist cases where dad takes all the kids to the nudist colony. Mom freaks out. I want to change custody. Okay? So this can get really tricky and really slippery. Now this one, G, obviously I can weigh in quite a bit. The mental and physical health of the parties involved, right? But some of these, so the permanence as a family unit of the existing or proposed custodial home or homes, I can weigh in a little bit on that, but typically I'll say, no, they both have established residence and they both plan on staying in the residence. Okay. All right. Am I getting your attention again? Right? I brought sex and perversion in and everybody's paying attention now, right? Okay. Just to expand for a minute, some of you may have been involved in these kind of situations growing up, right? Did your parents fight over custody? When I do a capacity parent, I say, whoa. I say, does this person have any mental illness, major psychological problems, or intellectual deficits, or active substance abuse problems? Do they have any problems? And if they have problems, how does it affect their ability to be a parent? So those become the basic questions in these capacity to parent evals. Forensic psychology is pretty big, isn't it? So a forensic psychologist in a consultant role, we've really kind of focused on the examination role. You can get hired, or I've been hired to do all kinds of stuff. Jury selection. I've been hired to help select a jury. But you know what the science says about jury selection? It doesn't work. There's been a few high-profile cases, right? The O.J. case. Remember O.J. Simpson? I did this talk 6 years ago, and it's on YouTube, and people comment on it, and they say, why is he talking about O.J. Simpson? None of these kids know who O.J. Simpson is. I guess I need to get newer examples. But jury selection got a lot of media coverage. And if you talk to any experienced defense attorney, they say, you can't pick a jury. There's no scientific way to pick a jury. But there are people out there who are charging thousands of dollars saying that they can help pick a jury if you're a rich person. This kind of hit a heyday in the 70s too. A lot of social psychologists tried to get into this business. But the science really hasn't played out. Oh, by the way, if you're a person who does this for a living, you're going to tell me I'm wrong. But it's argumentative, right? Specialized expert witness. So I'll be hired frequently to testify in cases where there may be questions of, I've testified about 5 or 6 of these cases where there wants to be a change of domicile. So you take two parents divorced, you have a 2-year-old, dad's going to move to California. He wants to fly the kid back and forth every week. Is that good for the kid? And I got to talk about the child development research and about attachment and bonding and things like that. Forensic record review, I already mentioned that. That's when I'll review a bunch of records, get a big box of records and read them all day and provide opinions to the attorney about the case, about potential legal strategies, about how to approach expert witnesses on the side. And trial prep, which sort of fits in with that. And I'm going to cruise through these. But, Dr. Jeff, when I become a forensic psychologist, won't I be carrying a gun and helping the police track down serial killers? As a forensic psychologist, won't I become a profiler with the FBI or the Hudsonville Police Department? I used to rag on Sparta, now I do Hudsonville. Okay. The Hollywood depiction of a forensic psychologist is different than what the day-to-day job is, as you're seeing. Profiling, boom. You heard of profiling, right? Profiling was used by what's called behavioral scientists. The first behavioral scientists in the FBI to do profiling had a BA in English from Dartmouth. Okay? I already talked about actuarial data sets, but what profiling started out with the idea that we want to find murderers and we want to find serial killers. And we're going to look at all these variables that are involved and associated with serial killers. If you took PY 201, you learned about research methods. Well, if you only have a database of 80 serial killers, that's not a very big database, is it? And if you ever noticed when this kind of hit its heyday, I mean, this was big probably 10, 15 years ago, they'd always identified the serial killer as a 35-year-old man, probably slightly overweight, likely lives with his mother, and wants to be a police officer, right? And unfortunately, some people got pegged. There was the Olympic bombing probably 15 years ago, where a guy named Richard Jewell, was a security guard at the Olympics. And if you remember, Olympic bombing was someone left a backpack, it exploded, and I think it killed a couple of people and harmed a lot of people. And they found Richard Jewell, who fit that profile. And they followed the poor guy around. He was a security guard. They lived with his mom. He fit all these profiles. It turns out it wasn't him. There's been a lot of other famous cases where they came up with the profile, and it turns out the person was very different. So this is kind of, the FBI Behavioral Science Unit is a real thing. This is way played up in fiction. Where it really works well now is used to try to catch bad guys. So if we can get more clues of the type of person and start to investigate different angles, maybe we can turn up the real evidence, not accepted in court. If I walked into Kent County Court and said, I think this person meets the profile, the judge would have me put in jail. No, not really. They'd throw me out of court. Judges go bananas when they hear profile, okay? Because just a lot of the legal cases that came out early on, we didn't know what profile was or wasn't. A lot of kind of really kind of well-known legal cases, people were severely harmed. So judges go nuts when you talk about profiles. So does this exist? Yes. It's not really, it's used to help understand some aspects of the crime to lead you to investigate different things to maybe get better evidence. Okay? But just using profiling, there's really not a great science to support it. What is a typical day or week like working as a forensic psychologist, and how do I become a forensic psychologist? All right. A typical day would be I would come in at 8:30, and I might see someone at 8:30 who's had their kids taken away for physical abuse, and I did their capacity parent evaluation. And then the next person I see is claiming that they're disabled and they can't work, so it's a disability eval. And then the next person I see is another capacity parent eval, but this time it's in a divorce. And then I eat lunch, and in the afternoon I run off to the Kent County Jail, and I see a guy who's there, and he's been charged with criminal sexual conduct, and his attorney wants a criminal responsibility and competency evaluation. And I'll spend the afternoon there. And then the next day, I'm doing court at 8:30, and I go testify in a termination of parental rights case. And then I get back to my office, and I have an attorney that calls and says, hey, we have a case of this. Can you take a look at the records? I say, okay, send them over with a check. I'll go over the records. We'll talk and do a half-hour phone consult next week. And then I got about 6 or 8 regular people, regular counseling clients. Normal people, right? That's a good number for me. I don't need any more, but I don't need any less, right? How do you become a forensic psychologist? Well, the main thing you need to do is, first of all, become a licensed psychologist. There are programs out there that says, come to our school, online usually, and you can become a forensic psychologist. And I get at least one email a month that says, I got my master's degree in forensic psychology from blank institute, and I can't get a job. The key is to become a licensed psychologist. If you're interested in psychology as a career, talk to your professors. There's different types of licensure. So for example, for me, I went and got a PhD at the University of Iowa, which that program's it's either counseling or clinical, makes you eligible for a license in most states if you do some other stuff. Like 2,000 hour internship, 2,000 hour, that's a year, right? Postdoc supervision, and then you take a national exam. So as psychologists, for say a doctoral level licensed psychologist, we all kind of go through the general training, but then you can further specialize. So what I did is I did my internship year with the Federal Bureau of Prisons in Lexington, Kentucky. They had a forensic training program. I went through and learned all my forensic work, right? And then, so I specialized after becoming sort of a regular psychologist. Now there are other ways to do it, but I always tell students, in particular when I get emails, the main thing you need to do is get a license to practice psychology. If you don't have that, you're not going to be able really to do forensic work. Okay? There are a few people in town who have a master's degree in psychology who are able to do some forensic work. They've taken lots of additional training. All right? But how many years of school, I get asked? Oh, it took me about 11. If a standard bachelor's degree is 4 years, and a doctorate's 4 more years, and 1 year of internship, I end up doing a little different. I end up doing a bachelor's, then a master's, then went on and got a PhD. So about 11 years. Okay. Went longer than I wanted to. Let's open it up to questions. And since I'm mic'd, what I'm going to do is you'll tell me your question. I'll kind of repeat it and try to answer it for you. So let's fire off some questions. Yeah. Who's that? Nathaniel Abraham was convicted of murder at age 11 in Michigan. That is a well-known case. And you ask me, was he competent? Well, here's the deal. I've had lots of cases where people were convicted and they never had a competency eval. Was he competent or not? I don't know. But I will say this, just anecdotally from my experience, it's hard to be competent at 11 to stand trial. The new statute in Michigan says if you're 10 or under, you're presumed not competent. 11, have I ever evaluated an 11-year-old that's competent? I don't think I have. I suppose it's possible if they're an extremely bright and mature kid, but 11 is pretty young. Yeah. Okay. Yeah. Yeah. And you'll see cases like that where people have been in prison for a long time, and I've had cases where I had a guy who was 10 years old, had fondled his friend's 3-year-old sister. They charged him with criminal sexual conduct. They didn't have good representation. They didn't even do a forensic eval for competency. He took a plea of criminal sexual conduct 2nd degree, and then he turned 18 and wanted to go off to college. And they said, no, you got to register as a sex offender. And that was probably 10 years ago, and it was one of the first test cases with the whole sex offender registry and trying to get yourself off. And I had to do a risk assessment on the guy. And he was a normal, sort of regular 18-year-old kid. Never had any problems after, went into counseling after that, after he got in trouble, and went through everything, and he hadn't had any trouble at all. And I did his forensic eval, and it went into court, and they ended up saying, okay, this guy's not a risk, we're going to take him off. But it really could have changed his whole life. But there was a part in the law where you could sort of appeal that placement if you were a juvenile. Other questions? Yeah.
What's the difference or similarities between criminology and forensic psychology?
The question is, what's the difference or similarities between criminology and forensic psychology? Criminology is a study of crime. Criminology stereotypically comes more from a sociological perspective, and sociology is the study of people in groups, where psychology typically is focused on the study of individual differences. So I guess the answer to the question would be, criminology comes from a societal perspective on why crime occurs and how to prevent crime and all those kind of issues, where psychology comes from the individual, right, the perspective of why the individual may be involved in criminal activity. Does that answer your question? Okay, back here. Right, so she's asking, when I talked about the example of the 13-year-old assaulted his mother with a box cutter and we found him not competent, what happens to a kid like that? Does he go back with his mom? One of the problems in juvenile justice, what do we do with these kids? The couple of judges at Kent County had me and one of my colleagues come over and sit down and talk. And what do we do with these kids that are not competent but really need help? We've done all kinds of things. In that case, I don't remember exactly what happened. That kid may have went into treatment. I had a case of a kid who was 12 who was sexually molesting all of the younger kids in the neighborhood. And then at church, he was really out of control. Family was kind of marginal. They didn't want to deal with it. And I saw the kid and he wasn't competent and he wasn't going to get competent. And they said, what do we do with this kid? He's kind of wreaking havoc. I said, why don't I do civil commitment on him? Why don't I go through probate court? And civil commitment is, we're going to put you in a psychiatric facility because you're a danger to yourself or others. We end up civilly committing him to long-term psychiatric treatment because the family wasn't going to do it. So we ended up going the civil route. I've done that on a couple of cases. I say I can write a great evaluation that you guys can use in probate court to say this kid really needs to be in a facility and be involved in intensive treatment. But the big problem is a lot of these juvenile cases, we have these kids who really fall through the cracks. And everyone's trying to figure out what to do. And then in an age where no one wants to pay for any treatment, there's a notorious community mental health center in this neck of the woods, I'm not going to name it, that continuously refuses to provide like residential treatment, pay for residential treatment services for kids who are on Medicaid from poor families. And I've had there was a judge that used to work in this county that used to send these cases to me, and I would say, given the clinical picture, this kid needs this type of treatment, and typical is a residential treatment. And then the judge would order it based on the forensic psychologist expert opinion, and then this particular community mental health agency had to pay for it. So it's always a problem trying to find out what to do with these kids. It's really a problem in the juvenile justice system, particularly when there's not as many resources in some, and it varies by county. Some county there's pretty good resources. Other counties there's no resources. And then you just let the kid go back out on the street. It's really difficult. So, other questions? Yeah. No, he was found not to be insane. What's important to understand is insane is a legal term, right? And one of the things sometimes that we get caught up in is when people do really, really awful, terrible things, and we say that person must be insane. I showed you what insanity, how it's defined in the law, right? So, yeah, I think they went for an insanity plea in Manson. I'd have to look that up. I don't know all the cases off the top of my head anymore. I used to. But a lot of times people will do really awful, twisted, sick things. And the assumption is they must be insane or crazy to do that. But we have laws that define what insanity is. And like I said, it doesn't work very often. Less than, 1% of the time it actually, making an insanity plea that's contested actually works. Other questions? You want one more? Okay.
My brother, he had killed someone in '92, and his lawyer had an expert psychologist, and they showed
Okay. So he's talking about his brother who was charged and convicted with murder, and the defense hired an expert that came in and said he had a crack in his cranium, I think he said, which is a fractured skull, and it caused damage. And he was still convicted because the psychologist on the prosecution said he still was sane or competent. So this brings up a couple points. And I don't know about your case or your brother, but the point is, just because you have a mental illness, mental retardation, or a mental disease or defect does not automatically make you not competent or not insane. And what you're talking about is a battle of the experts. Now, I'll get called in on it as a second opinion all the time on these cases. The Forensic Center in Ann Arbor does all the forensic evaluations for the state of Michigan. And I get a lot of work that the attorney doesn't believe it, and they'll send the case to me, and I'll do the same type of evaluation that they do. Most of the time, I agree with them. Sometimes I don't. Sometimes their work, in my opinion, is a little shabby compared to what it used to be because they don't get called out. Another important thing is there have been trends in forensic psychology. Back in the early 1990s, there was a psychiatrist and psychologist who traveled the country, took a lot of money from people, would go in and testify that because of partial complex frontal lobe seizures, the person is insane. And it would always turn out they'd always be found sane, and these guys would go to the next state. So there can become cottage industries with some experts. Parent alienation syndrome, which is this idea that there's a divorced family or a divorced couple, and the one parent has brainwashed the kid to hate the other parent. There's a whole cottage industry that was really hot 10 years ago, but I testified in a case for 7.5 hours last month. They brought in their parent alienation experts from Ann Arbor, and rich people fighting, spending thousands of dollars over this kind of expert who was just a gun for hire. So you'll see that. The thing that I predict, and when you do this talk in 20 years, right? Brain imaging. The new thing we're starting to see is people are coming up with sort of new brain imaging techniques, MRIs, and saying because of that MRI, that's why the person did the crime. Think how complicated the behavior is of breaking into someone's house, beating them, and then leaving and trying to cover up the crime. That's a pretty complicated behavior, isn't it? Can we say that you did that whole entire series of complicated behaviors because of one little blip on an MRI? I would argue probably not. But what you're going to see, my prediction is you're going to see as these imaging techniques of the brain become more and more advanced, you're going to see more and more hired guns that are going to take these and try to use these in criminal proceedings. It'll become the new trend that you'll talk about when you do this talk. Okay? But it's one of these things that you see the trends come and go. Other questions? We got 10 minutes? Yeah. He had a full medical workup. It was actually at the University of Michigan Hospital. From the time he was little, I had about that many records to go through. And they did a really good workup on him, and they were following up. He was getting really good medical care. But still, I don't remember all the specifics, but still the endocrine problem caused just significant difficulties in his ability to kind of take care of himself. And he had some cognitive manifestations of that. And that was one of those things that really wasn't going to get better. And there was a medical, based reason. So his medical problem affected his mental status. I evaluated mental status. I looked at the records to establish there was a medical problem that we connected to the impairment in the mental status. So, other questions? Yeah. He's asked if I have one thing in my practice that I do more than others. Right now, about 30% of my practice is capacity to parent evaluations, either through neglect and abuse or divorce. Probably about 20% of my practice is criminal, and that's competency to stand trial most of the time, or criminal responsibility or insanity. Probably about 15% of my practice is disability work. People are claiming that they can't work because of a psychological condition. Probably about 10% of my practice is civil litigation. Had a wrongful death suit that I'm wrapped up in. You get these cases, they're just immense. That I got to go over to Ann Arbor to testify in probably next month. It was a hospital mistake and someone died and suffered a lot. So I had to go and look at the research literature on pain and suffering and near death. So a lot of times what happens is I'll have to go back to the literature on cases or topics that I don't know everything about and then be able to testify about it. And then the rest are just some counseling and some other random things. So it's I try to keep, my goal is to have about 20% in each area. So then if one drops off, I'm still okay. Other questions? Right, yeah, I'm a busy guy, believe me. Yeah. I don't do much treatment. I do a lot of examiner and a fair amount of consulting. I don't do a lot of treatment cases. Mostly, if I do, it's mostly parenting coordination. So mostly examination. Yeah. No. To have a job after this many years where every day is interesting is a major blessing. I'm never bored. And every time, as a psychologist, you think you've heard it all, something new comes in. I mean, some of my colleagues have been practicing for 40 years, and they say the same thing. So I'm really fortunate to have a job where, I worked in the prisons because of the administration. That job was not fun anymore, and that became boring. But I'm pretty blessed right now. And I told people, I'm very busy because people continue to mistreat each other. It's kind of weird, isn't it? But no, I'm constantly interested. I never feel like I've got routine cases. I'll see the same thing, but it's individual people in individual situations, so it's never boring. Sure. So she's asking, could I give an example of a capacity parent eval where someone was deemed, did not hold a capacity parent? No intention towards stereotypes here. Giving you a regular case. No example. Single mom, 23 years old, 4 kids, 4 different dads. None of the dads are involved. Mom works here and there. She's got some problems with smoking a lot of weed and drinking. And she's been a victim of domestic violence from 4 different guys. And the guys kind of move in and out of the house. And it turns out she got really high and fell asleep, and the 3-year-old got out. So kids were pulled, put into foster care. I do the capacity parent eval. What do I find? Well, I do the full exam. I find out there's a substance abuse problem. There's marijuana dependence. There's another problem with alcohol abuse. This person also has some dysfunctional personality characteristics that lend them to be involved in situations, in relationships where violence is an issue. This person really doesn't have much of a motivation to parent, and I do the Parenting Stress Index, which is a test, and they show extremely high stress in their perception in the parent-child relationship that they think is due to the kid. Okay. So, what do? The kids are in foster care. Mom has a year to get it together. So I make recommendations. Boom, substance abuse treatment and random drug testing. Okay. Number 2, parenting education class, because we did an assessment of her parenting or knowledge of parenting, and she didn't do so well. She needs to learn about parenting. Number 3, we're going to put her in individual counseling so that she can learn better coping skills, can gather some insight into her potential dysfunctional personality characteristics, and also have a person who can emotionally support her because she has no one. Number 3, we're going to recommend vocational rehabilitation or job training, because instead of partying and hooking up with bad guys, maybe she should find a job. That could be helpful. We're also going to bring in other social service interventions to help her find daycare for her kids if she gets her kids back while she goes to job training. We're going to also put her in a domestic violence group. right? Because she's had this repetitive pattern of domestic violence, domestically violent relationship. She needs to learn how to avoid those. And the whole focus is what's on the best interest of her children. So for her to correct all those things would be in the best interest of her children. So that opinion might be at the current time, she does not have the necessary psychological capacity to parent. But these are the ways that she can attain that. And let's say mom quits doing drugs and alcohol, starts testing clean. Let's say mom goes into counseling, does well in her counseling. She goes to a domestic violence group over at Fountain Hill Counseling Center and gets into the group and does well. She actually gets a mentor, okay? And let's say that she ends up going into a job training program and she learns a skill. And then the court sees her at the end of the year and they say, you've really turned your life around. They send her back to me. I check all this out. I say this person has now established the necessary psychological capacity to parent. And then the courts say, here are your children back. Let's say she doesn't do all this. Let's say she continues to party. She doesn't show up for her visits with her kids. Okay? She gets arrested a couple of times. She gets in a couple of domestic violence situations. A year goes by. The court says, Jeff, we're putting you on the stand. When you started, did she have the capacity to parent? I said, no. They say, what did you need to do? Or what did she need to do to establish this? I lay out the recommendations. The court says, Jeff, she didn't do this. I said, well, then I'd be concerned about her capacity to parent. And I know this is awful, then they'll terminate the rights. And then the kids are eligible for adoption. So that's a kind of a rich example, but those are the kind of things that you deal with day to day on these neglect abuse cases for capacity to parent. Other questions? Yeah. I've had 2 of those cases already. Yeah. So, yeah, the Supreme Court said you can't just put juvenile offenders away with life without the possibility of parole. So where the route they're going now is more resentencing rather than retrying. So I've had 2 cases. The one I can tell you, the one's still in process. I don't really want to talk about it. But the one case was, it was a 16-year-old guy who basically was in a gang and got drunk with an older gang member, and they went out for some retaliation, and they beat a guy up and kind of shot him execution style. Maybe you know the case, I don't know. So I get this referral, and I have to figure out, all right, what questions do I need to answer? Well, there's no precedent yet in Michigan. So I look and see other states that have followed this, what type of things they're looking for. I look at some things that came out from the Michigan Supreme Court decision that says this is why we can't put these kids in prison without parole for their whole life, A, B, C, and D. And I go, oh, those are some of the questions. So I had to formulate questions based on some of the precedents in other states, based on, and I got that Supreme Court decision and looked through that and came up with questions. For example, one of the questions was, in those types of cases, to consider resentencing, was the juvenile significantly influenced by an adult, an older person who they may have looked up to? And was the juvenile living the life of an adult versus the life of a typical juvenile? In the case that I testified and that I evaluated, I didn't testify, this guy had basically been living on his own, selling drugs for a couple years, had his own apartment. Knew his family, hung out with his family, but he was on his own. One of the guy that he was hanging with and they did the crime was 21 years old. And I came back to the attorney and I said, you know what? He doesn't meet the criteria of what the court says he should meet in order to resentence. And the attorney got really mad at me, but I just call it like it is. And she didn't use me in the case, and then of course the prosecution wanted to use me. And she, got that squashed. And the guy, they did not resentence him. So he's still doing life without parole. But I would argue that the Supreme Court decision wasn't really designed for a guy like that. It was designed for the 13-year-old who's with 4 or 5 guys that are 20, and they do a drive-by shooting. That's complete, or in the robbery. They'll do it, like 3 of them will do a robbery, and the kid ends up shooting a clerk, and he's 14 years old. That's the reason that's the kind of case the Supreme Court was really looking at when they made their opinion. This guy didn't fit into that. Yeah, that's when there are arguments that this kid wouldn't have done this on his own. He was, influenced and kind of driven by the older peers. Any other questions? Yeah. So she's asking me what's my take on some of the newer diagnosis in the DSM, DID or ODD, DSM, Diagnostic and Statistical Manual Mental Disorders, right? The book, where all the diagnosis. DID used to be called multiple personality disorder. I've had cases with that for sure. We're running a little over, but I'll tell you a good juicy case, or what they call a sexy case in forensic. When I was in the Federal Bureau of Prisons, my supervisor, I worked one-on-one with, said, "Hey, we have a kidnapper coming in. Why don't you do it? Why don't you evaluate the kidnapper? We never had one of these. You have never had a kidnapper." I said, "Cool." Guy comes in. My supervisor, Andy, goes, "Wow, I shouldn't have gave you this case. He was a serial killer who was abducting women at rest areas, transporting them across state lines, doing all kinds of nasties and killing them. It's federal crime across state lines." He got off by reason of insanity in Arkansas because he claimed he had multiple personality disorder or dissociative identity disorder. He had an IQ of 130, which is like 98th percentile. He was a psychopath and extremely bright. So we'd bring him in to interview him, and he'd say, "I don't have any memory of those times. I don't remember anything." So my supervisor, Andy, said, "Go to the University of Kentucky Library for 2 days. All I want you to do is read about multiple personality disorder and dissociative identity disorder." So I went there every day and read it, and I learned a lot about it. And we came back, and the people who have true multiple personality disorder, when they're in their core personality, their main personality, they don't know about the other ones. All they knew is they lost blocks of time. Where when they fake it, they say, "Oh, that's Rex and that's Johnny," and they're faking it. So this guy was good. One of the nurses on the unit said, "Have you ever seen this movie?" And it's an old Richard Gere movie with Ed Norton, where he ends up killing a Catholic bishop. I can't remember the name of the movie. But he said, "This guy acts just like that." So Andy and I both rented the movie, watched it. And we said to him, "You've been diagnosed with multiple personality disorder." And he said, "That's bullshit. I don't have multiple personality disorder. You guys are making that up. I don't." But we were recording his phone calls to his wife. "Honey, I've got multiple personality disorder. It really wasn't my fault." And the other thing we did is he was a big Green Bay Packers fan. And he had a block of time, which was right around the Super Bowl when Green Bay was in it, that some of these murders took place, that he said he didn't remember that week. Some Sunday night, one of the nurses had the radio going, Green Bay Packers. He was in a cell next to the nursing station. He said, "Hey, are you listening to Super Bowl?" Yeah. Brings it over, starts talking. And the nurse starts talking about the Green Bay. "Oh, did you see that game?" "Yeah, where were you?" "I was in this bar in Morgantown, West Virginia. And I was with my ex-wife, and we watched this game." And he started talking about all the things he did during that week. And the nurse sat on the other side of the door and wrote it all down. And then we brought him in. See, this is a glamorous case, right? Like TV stuff. We brought him in, and we played the tape of him talking to his wife. And he goes, "That's not me. You guys made that up." Anyway, he's doing life without parole. Last I heard, he was in Pennsylvania. Scary, scary bad guy. But so that was a case where dissociative identity disorder came in. The guy was extremely bright, smarter than me and my supervisor, had done his research, and he pulled it off. But he didn't pull it off with us because, he was quite a case. We had him for 30 days. And we were able, and that was, recording his phone calls was lots of fun because he'd call other people, and he couldn't keep his lies straight even with his high IQ. So that's my big glamorous case when I was with the feds, where DID was brought in. And ODD, oppositional defiant disorder, gets brought in too with kids sometimes. But you have to talk more about the diagnosis, and typically that won't work in the case law. So different diagnoses are played out in different case law. You want to talk another 2 hours?
What do you think?